Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Hello, this is the third lecture of our Bankruptcy and Debtor-Creditor Law section of the course. The cast of characters and their roles in the bankruptcy process will be covered. Kind of looks like a long list, but it really is not. I would say that from this list it might be a good idea to come to it for some definitional stuff and look at the applicable code sections and rule sections that might give you some insight to some of these roles that are played. Most of it, if you know the court system of law, you have a pretty good idea of what's going on. But we'll need to focus on the debtor and the debtor's attorney, the debt relief agency, the petition preparers. I'm not really covering that in this, but they do exist. The administrative office of the United States courts and the judge and staff. So relatively short lecture, pretty ordinary stuff going on in this part. So who is the debtor? The Bankruptcy Code, of course, has a definition of debtor, and they used to use the word bankrupt, now it's debtor. Debtor is a person or a municipality, and a person doesn't include a municipality, and a municipality does not include a person. So there are two distinct things. Persons are, as described, an individual, a partnership, and a corporation. So don't get too much worldly, fleshy stuff going on in here, because we do have persons that are not fleshy people. That's a good term, I don't know. A person cannot be a debtor under the code unless the person resides or has a domicile, a place of business, or property in the United States. So those are some foundational terms that are important to understand about the debtor. An individual family farmer may not be a debtor under the code if they've been a debtor in a case pending under the code at any time in the preceding 180 days. So realize the individual family farmer can be filing as an individual, can be filing under the Chapter 7 or 13 or one of the others. But it's just, we're pointing out here that if that's happened, the individual debtor, who happens to be a family farmer, files bankruptcy and then tries to do the family farmer type of bankruptcy, it won't work. So here's some, if the bankruptcy court dismissed the case for willful failure, if the debtor requested and received a voluntary dismissal. So, pardon what I just said, they can, but there's some certain parameters. These two parameters are placed around that individual versus family farmer. The debtor is an individual, cannot be a debtor unless they've received an approved non-profit budget and credit counseling agency counseling. And they have to have that within 180 days of filing the petition. So realize that can be within 180 days. The opportunity has to be taken and proof has to be provided to the court. And in quizzes for this section, I can't remember, I think it's this one. There's some questions on this topic. The paralegal obviously is someone who is trained and experienced to work in the role, and they're not allowed to advise the client or represent the client in judicial proceedings. Bankruptcy court does not have a carved out opportunity for non-lawyers. The debtor's attorney, it will determine whether there's need to determine whether there are alternatives in bankruptcy. We'll discuss that a little bit today in this lecture. And where there are no other alternatives, the debtor's attorney will begin gathering that information needed to file the documents. They supervise, obviously, the paralegal, and will file motions as needed, and will represent the debtor at the meeting of creditors and all other required proceedings. The paralegal's role: interviewing, investigating, and legal research, and drafting. The Debt Relief Agency came about with the BAP-CPA, Bankruptcy Abuse Prevention and Consumer Protection Act. By the way, I realize I have a typo there. It includes a person who provides bankruptcy assistance in return for payment. So your lawyer falls under this debt relief agency piece, and I think when we get to the forms lecture on this, you'll see kind of how that connects. An attorney is a debt relief agency if they provide bankruptcy assistance in return for payment. So just keep those three functions in mind. That adding that attorney to this debt relief agency is part of BAP-CPA, so that's something to consider. One moment here. So I'm the type that says if it needs to be fixed, fix it now if you can. So I just fixed up my language here to make sure we're including the right name of the BAP-CPA. All right, the creditors, they can hold secured claims, unsecured priority claims, and unsecured claims. These three types of claims will be important to study in your vocabulary for this portion of the test. It'll relate to some I don't think they're open-ended questions, but some questions that I see in the preparation manual by NALA tend to ask about things like, if there's a secured claim, priority claim, unsecured claim, what would you do type of questions. So if I were you, I would definitely make sure you are studying, well, for one thing, I mentioned in a previous lecture on the bankruptcy laws where you can find definitions. So use those definitions from the code. Really important. Flashcards on that will really help you. Vocabulary is an area that if you learn the vocabulary, you're better able to analyze the problems that you're faced with answering in an exam or in line of work. So a creditor holding a secured claim, they have secured claims with a security interest in real property, personal property, or fixtures. So think about your mortgage, think about your car payment, think about the air conditioning system that was purchased for the home and installed. It's a fixture that probably may have had some debt associated with that purchase and installation. So the security interest is important because then the creditor then has a right to repossess the collateral if the debtor defaults on the obligation. If they're holding an unsecured priority claim, this means that it's unsecured, meaning there's no property attached to it, but there are categories of the unsecured priority claims that have special priority in the bankruptcy code. So domestic support obligations, administrative expenses, extension of credit in involuntary case, wages, salaries, and commissions. Moving on, contributions to employee benefit plans, certain farmer and fishermen, deposits by individuals, taxes owed to governmental units, etc. So realize that these are claims that creditors that possess these claims have a priority interest in the estate assets, and oftentimes these are non-dischargeable debts, but not always. that since they're attached to oftentimes a right, for example, that previous slide had child support and that sort of thing, they're attached to some things. BAP CPA has really honed in on priority claims. Creditors holding an unsecured claim, which means they're not secured by collateral. This is your standard credit card. So if there is any collateral, some credit cards do have security interest, by the way. You buy something at at some locations, like electronics stores are typical. They'll have a security interest, and if there's a value to the security interest, like I bought a computer, let's say, with a computer at Best Buy or whatever one of these stores is, then Best Buy does have collateral interest, so they're secured. But everything after the value of that is deducted is unsecured. And then there's also and these won't qualify as unsecured priority claims either. These are just, I just call it standard type of debt many Americans have. Unsecured, no property interest attached to it. Other parties in interest are equity security holders, indenture trustees, statutory lien holders, lessors, governmental regulatory authorities, etc. Administrative Office of the United States Courts plays a large role in bankruptcies. The judge and staff obviously do. The Office of the Clerk at the Bankruptcy Court, obviously. The United States Trustees, which we'll get more into their roles in the case, I think, in the next lecture. And examiners play a role in that. Other characters in the bankruptcy process, some states like Alabama and North Carolina have bankruptcy administrators instead of U.S. trustees. Keep in mind that some state laws do overlap with the federal laws, depending on the election of the state in terms of what they're taking from the federal laws. So just keep in mind, it is still federal law. The state laws will have an overlap in terms of their bankruptcy laws. They can make some elections. So not important to get too deep into that. That's why you see the two states that are federal. The bankruptcy administrators and the United States trustees, these are like the oversight of the trustees. And the Administrative Office of the United States Courts obviously has a role in bankruptcy administration. And the Department of Justice administers the United States Trustee Program. So they're the head of the head. So the United States Trustee Program is a federal program that has several layers of oversight, including the Department of Justice. So, a quick review. We've got the debtor, how they're defined, what the debtor's attorney's role is, the paralegal's role, what types of work the paralegal will work with, and debt relief agencies, including attorneys, as we've already discussed. Those were established by the BAP-CPA, BAP-CPA in 2005. Creditors and their claims, there can be secured claims, unsecured priority claims, and unsecured claims without a collateral attached to it. And we have equity holders, those in the last couple of slides. These are the administrative, a lot of it is the real administrative role of the bankruptcy trustees, etc. Okay, so that's the last slide. Moving on to lecture number 4 here in a little bit. Thank you. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also, there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.